Now, the Pontiac School District and its co-plaintiffs took the position that they could not be obliged to spend any own source revenue, any revenue derived from their local millage or sales tax, on compliance with the Act. And that's not an implausible reading. You could read the term, any funds or costs not paid for under this Act is any funds that are not derived from federal revenues. But if you take that position, not an entirely textually lunatic position, you get the bizarre reading that they don't have to spend a penny of local revenue on low-performing kids. They could simply say, we're going to use the federal revenue to pay for the tests, the charter schools, the tutoring, or anything else necessary to comply with the Act. And by the way, that's roughly a very small, $14 billion spread among 19,000 school districts throughout the United States is a tiny amount of money. And then be off scot-free. Essentially, that would gut the main purpose of the Act, which is to ensure that these subnational jurisdictions pay attention to low-performing kids. So you have a textually plausible reading offered by the school district, but then you also have a federal interest that would be ignored if you took that school district's readings seriously. What's the federal court to do? Well, the Sixth Circuit didn't know what to do. It was divided right down the center. And I want to suggest that that is part of the whole problem with mixed public goods. Here's an example which I want to close with. Brandon Township School District claims it needs $390,000 to make its annual yearly progress. That's how much extra money it needs to make sure that low-income or poor-performing kids meet the federal standard. How do we know that's right? Well, first of all, Brandon Township School District has an inherent interest in educating its kids. It's not like they're saying, look, if you take away the federal grant, we're just going to throw them in the river, right? It's not like they're going to say, we're not going to send them to school at all. So it can't be that the entire cost of, say, a charter school for these kids must be funded by the feds. Some percentage of that cost has to be funded. What percentage? Well, the percentage necessary to overcome the indifference of the school district as resulting from, say, the entrenchment of a local political machine, the dominance of middle-class parents, you name it. I don't know what that sum of money is. And without finding what that sum of money is, we don't know whether requiring them to use own source revenue to pay for the federal mandate is requiring them to pay for pay for things that are not funded under this Act. Because presumably some share of the interest in these kids is both a local interest and a federal interest. Now, faced with this conundrum of mixed public goods, that we cannot extricate the local from the federal, the notion that the federal courts are going to come in and strike down federal grants that either don't cover the local cost or go beyond the federal interest strikes me as deeply implausible. But finally, I want to suggest why it's inadvisable. Any such standard will be unbelievably policy-laden and mushy. And whenever you give courts a discretionary, mushy, policy-laden standard, they're going to be open to the accusation that they're politicized. Law, like nature, abhors a vacuum. And if you have a law that is essentially standardless or mushy, pure policy, then you can guarantee that judges, not because they're bad or partisan, but simply because they have to draw on something, will reach for their partisan intuitions to fill the gap, or their ideological intuitions. In the Pontiac School District case, there were 8 votes to strike or to find that there was an unfunded mandate in violation of the federal statute. There were 8 votes against that position. 8 votes, in other words, upholding Bernie Friedman's position that the case should be dismissed and there was no violation of federal law. The 8 votes that said there was an unfunded mandate came with one exception from democratically appointed judges. And the Republican has a reputation for being a liberal-minded, protege of Lamar Alexander. The 8 votes on the other side were all Republicans. Now, I accuse no judge on the Sixth Circuit of being partisan. But I want to suggest that those kinds of lineups are inevitable if you say to judges, here's the legal standard, do the right thing. What are they supposed to draw on if you say, promote the general welfare, except for their general intuitions about policy? And should it surprise us that a protege of a Republican or somebody who believes in Republican principles is going to find that, for instance, No Child Left Behind serves important federal interests, and that a protege of, say, Ted Kennedy, who was denouncing unfunded mandates on the floor of the Senate, will find the opposite? I doubt it. And so it seems to me that if you're going to give judges this standard to enforce, you're going to set them in a position that they can't possibly sustain and open them up to legitimate criticisms that their decisions will have to be driven by partisan politics. I don't think that's a wise thing to do. I don't think it's a necessary thing to do. And therefore, although I am a federalism nut, I would not ask judges to enforce this particular constitutional limit. Thanks.
Thank you, Rick. My blood pressure was really high during that. I wrote one of those opinions, and having Professor Hills grade my paper right there as I'm right next to him was very tough. I must come. I'm not sure I disagree with a single thing he said, except a little towards the end, to defend my court, which, forgive me for indulging myself in just this a little bit. On the side that said there was an unfunded mandate, there were actually two Republicans, and on the other side, it was a little more mixed than that, in the sense that there were there were three that said we shouldn't even reach the issue. So it was really a procedural point. So the word partisan always makes judges very defensive, and so forgive me. But I think I agree with what you said. You did say at one point that this 7907A, there was a plausible interpretation of it that was advanced by the plaintiffs, and my whole point was that it wasn't plausible. But we'll see. So these are four great presentations. I wish we had more than 35 minutes to follow up with questions. I'd like to start things off with one or two questions, and then we'll start taking them from the audience. A couple themes here. You know, there's politically enforceable federalism. Another way of saying that is we rely on the self-restraint of Congress and the self-restraint of the states. The self-restraint of Congress turns on whether it's a politically popular thing to do. The self-restraint of states turns on turning down hundreds of millions of dollars. So one question is, I think everyone here agrees that there is something called politically enforceable federalism. The question is how useful it is. That leads to the question of whether there is such a thing as judicially enforceable federalism. John Eastman suggests that one of the things the court missed in South Dakota versus Dole and has continued to miss is that the spending must relate to the general welfare. And Malcolm, I definitely appreciate your concerns about whether any of these lines are judicially enforceable. But I'd be curious if you think John is onto something, whether general welfare is something that's judicially enforceable, whether the test that is out there, coercion, is judicially enforceable. And my one kind of suggestion that maybe it can be, at least in some settings, is it doesn't seem that the test here should be whether the doctrine is too mushy. I mean, if that were the case, we wouldn't have substantive due process. I mean, there's certainly a few doctrines out there that are difficult to enforce, that lead to line drawing, that lead professors to say that this forces judges to act in policy-based, even worse, partisan ways. But we still have them, and they're growing and not shrinking, I would say, at this point. So why can't there be a judicially enforced federalism? Why don't you start, and then let's respond.
I guess I think that basically it's a fundamental political problem and a problem of political will. And Rick pointed out that there's not a federal system in the world, at least a big one that we know of, that has a provision like this that is enforceable. So my position is that sooner or later Jesse Chopra will be vindicated in his argument for the political enforceable doctrine, and I think the court will come back to the only sensible conclusion, I think, which is the issue of federalism is a non-justiciable issue.
John, I'm curious. You can respond, but I'm curious. One thing I didn't hear you mention is, do you think the coercion test is not worth anything? I mean, you suggest that by running to another one.
Well, I mean, I ran to the other one only because it's prior in both time and kind of analytical thinking. I mean, if you don't have a general welfare, you don't get to either relatedness or coercion test. I think the coercion test becomes almost impossible to find a judicially enforceable line. I actually think the general welfare test is much more enforceable as a judicial matter than the others. And the presidents that issued the veto messages didn't seem to have any trouble saying this crossed the line and therefore I'm going to veto. In fact, the early presidents thought that their veto authority extended only to vetoing things on constitutional grounds, not on policy grounds. We've kind of flipped that understanding in later years, but that was the reason you would veto something. And so they didn't think it was an unenforceable test, where the general versus the local.